present it in clear and understandable way. We'll mostly focus on businesses either using AI or deploying AI and developing AI systems and services. So let's get started. Welcome again. My name is Igor Sudakov. My partner is Hanna Troska. We are Pixel&Protocol. We'd like to talk about AI privacy and compliance for startups today. Hanna, please.
Yes, hello everyone. It's lovely that you had a chance to join us today for our workshop. I'd rather not call it small, but still it is. So let's start with our first block. It's about the data privacy, security, and compliance to the major privacy laws, namely GDPR and CCPA. So let's start from the basics. What's actually GDPR and CCPA is, and what's the difference? I'm pretty sure that almost every one of you have heard about those pieces of legislation in privacy field. So saying plainly, GDPR is a privacy law in Europe, which focuses on how you collect, use, and process and protect personal data. CCPA is pretty the same thing, but in California. And focuses on transparency and control. So in short, GDPR is how you handle the data, CCPA, how you provide users with control over their data. And both of them affect how AI startups manage it. I think the question that now you have is, okay, if I'm in Portugal or somewhere in Europe, do I have to comply with both of them? In short, yes, but it depends. I mean, if you're in Europe, GDPR is a must. What comes to CCPA, it really depends on where your users come from. If you process significant amount of users data from California residents, it means you have to take an eye on both CCPA and GDPR. But here's the thing. Both GDPR and CCPA were written long before the AI boom. They still apply, and sometimes they clash hard with how AI actually works. So to give you an impression and the feeling of how it is, at the core, both laws say, if you process personal data, you have to be transparent. You have to be fair. You have to be secure. You have to give people control over their data. And now let's apply that concept, the basic principle, to how actually generative AI works. And you get the problem. Things get really complicated. So in this part of our presentation, we will try to walk you through the three big pillars of compliance. It is data breaches. Sorry, I lost my presentation. It is data breaches. It is regulatory compliance, and it's cross-border transfers. And we will see how they collide with the modern AI use cases. So let's start from the beginning, the data breach. Sounds terrifying, right? What's the risk? What usually happens? Usually startups using AI systems, they store customer behavior logs. That's important. They store chat transcripts. They store emails. They train data sets scraped or collected over time. And all of that is actually personal data. And when, not if, but when that data leaks, either because of bug or misconfiguration or attack, it doesn't matter. It's a data breach. And you have to be aware of it. And you, under the GDPR, you have only 72 hours to actually notify authorities, notify your users. And it's actually might be a real compliance burden. It's might be a problem for you because apart from like ordinary businesses, AI systems, they often collect and retain more data than necessary. That means almost any breach may be a breach when you have to notify the authority. And it's not always easy to tell who has access and when actually the breach has happened. And that's also involves a lot of uncertainty in this case. I think it's good time to support my words with the use cases prepared by Yegor.
Yeah, so briefly, data breaches that involved AI services, they mostly concern OpenAI. Last year, a hacker accessed OpenAI's internal employees forum and took details about design of OpenAI systems. No personal data access was reported, and no harm was done. However, in 2023, there was an internal bug of ChatGPT, and some billing data of like paid customers of ChatGPT and titles of their chats, they were exposed in this breach. But again, nothing's been like widely reported. There was like no follow-up enforcement. And final example about Microsoft AI researchers when they exposed 38 terabytes of internal data. And this was huge because it contained a lot of sensitive information, passwords, keys, 30,000 Teams messages. No harm again was reported. This just shows the scale of problems which might happen in the future. Back to you, Anne.
Thank you. So let's dive deeper into compliance. And when we're talking about GDPR and CCPA compliance in AI, actually we have 5 major challenges. The first, I think it's legal basis in data collection. Well, GDPR says that if you want to process something, you need a legal or lawful basis to do this. CCPA says you must provide a notice to your user and ability and possibility to opt out from processing. What it means actually in real life, you just can't scrape data, put it into a model and hope that no one will notice. It just it doesn't work like it works like that, but the GDPR is not expecting you to do exactly that. The second issue is user rights and explainability. What I mean, under the GDPR, and we do remember that GDPR still applies to us if we are based in Europe. GDPR gives users vast rights. I mean, right to access their data, right to delete their data, and those rights apply even if their data is an AI model. The problem here is that most startups, even if they want to respect the user rights to be forgotten, the user request to delete their data, they just can't do it. And it's because of the complexity of their systems and models they're using. The third challenge is actually privacy notices and transparency issue. What it means. Under the law, you are expected to disclose what AI tools you use, what personal data goes into, what kind of outputs the model generates. And that information should be clearly stated in your privacy notice. And that is why it's not a good idea to actually use the automatically generated samples from the internet, somewhere from the internet. Because if you are developing such a complicated product as the one using the AI model, well, that's the specifics, the sample from that site from the internet will not be taken mind. And then we have to mention vendor and model accountability. What it means. It's important to keep in mind that when you are building a product that uses AI models provided by the third parties, you are still responsible if something happens with your users' data. Even if you didn't build a model, even if you don't know how exactly it is made, how it was trained, and it doesn't matter if you don't directly control where it runs, you are still responsible. And that's not obvious, but still, at the moment, this is how it is. The final, I think, challenge regarding the compliance issue is actually bias, fairness, and safety. I won't put a lot of attention here because we will have a separate blog dedicated to this issue a little bit later during the presentation. And now I think it's good time to get some real-life examples of how GDPR and CCPA compliance actually played.
Yeah, the first example is from Italy from last year when Italian regulator pursued OpenAI for its processing data without adequate legal basis, transparency failures, age gating issues around ChatGPT. And for this reason, what are the practical outcomes? A lot of companies launching AI features, they do not launch them now in the EU because of this uncertainty, because they still haven't figured this out. For example, there's been a recent news that OpenAI is launching applications within ChatGPT. So services like Booking.com, Expedia, Spotify, Figma, Canva, and others, they would be available to work within ChatGPT, but this feature is not available in Europe at the moment because they still haven't found proper basis. They're working with that, and they promise to launch it in the future. Another example is from Meta, when there's been questions about how they train their models based on the content available in the services like Instagram, Facebook, and others, which they control. They had to pause training of their models in the EU and the UK after Irish Data Protection Commission got involved. And then they launched it again, and they said that we will be using public content, public publications with an objection option for users. So this is, for example, is currently done by Microsoft and LinkedIn. All your public posts would be used for training LinkedIn AI models. If you don't go to settings and just say I opt out of that, I don't want my public post to be used for that. So these are all examples for now, and we'll go back to cross-border transfer. We'll cover it really briefly.
Yeah, and actually the cross-border transfers is actually our next point. Cross-border transfers also sound a little bit terrifying, but what was the take here? When you use, for example, ChatGPT, it means you are using United States-based services. OpenAI, or well, if you use Gemini, you use Google Cloud, etc., etc., etc. Actually, technically, it means that if you have Europe users, you're transferring their personal data from European economic area outside the EU to the United States, and under GDPR, that's highly regulated. So, from the legal point of view, you're required to sign a special contract with the recipient. I mean, in our example, with the OpenAI. Possibly, it depends on what kind of data and the amount of data. You might have a dedicated document called transfer impact assessment. And most importantly, you have to inform your users of your product, where the data goes and why. And all of that sounds easy until we apply it to reality. In AI products, data moves dynamically from EU to US, from US to India, from India to Canada, from Canada to EU. You have to be aware of the very best net of providers of processors. And that's actually a problem because some providers, they don't really give full visibility and allow you to share information about the data residency. And that's actually the issue. I think there's nothing we actually can do about that, but it's always good to just keep in mind that to actually be aware that at least ask your provider, your vendor to provide you with the information and send something, at least something telling where the data goes. And I think Igor will share the amazing example of fines you may pay if you do not respect this data transfer obligation.
We don't have any practice yet involving AI companies, but we have examples of Meta and other US-based companies. And it's been long legal procedures by a very known in privacy world individual called Max Schrems. So he's been challenging data transfers from Europe to the United States and killing all the instruments the European Commission and the US government has been negotiating over the years, which affected how businesses work with Europeans' data. And it ended up for 1.2 billion euro fine for Meta in 2023 from Irish Data Protection Commission and suspension of Facebook EU-US data transfers. Then, again, the European Commission and the US government, they negotiated another transfer mechanism, which is active now. You can use it. It's called data privacy framework. However, this is always like a tricky question, and the services you use, they might be affected in the future because of this problem with data transfer. For example, if you're using Instagram, you might have seen offerings from Facebook like you can pay for your Instagram for using Instagram in Europe, or you can agree to seeing personalized ads in Europe. Because that's been the question, that's been the challenge, and you either have to pay or say like, okay, to targeted advertising on the Instagram. So that's the practice, and we're moving to like practical tips in this block.
Yeah, so I think you're thinking that so we gave you a lot of information. So what actually we have to do with this? How to be compliant? What does it? What's the input? So the practical tips are actually they're simple. First of all, map your data flows. What it means? It means know what personal data you are collecting. It doesn't have to be something very complicated. Just make a simple list. What data you're collecting from the users, where does it go, and why are you using it? Like for what reason? Because it empowers your product, because you need it for your internal analytics or any other reason why your business uses it. Just make this simple list and that will solve a lot of your questions. Also, don't forget to tell your users that you're actually using AI. As simple as, again, nothing so too special, nothing too legalese. Just a simple disclosure saying that you actually use AI tools, why, for example, support chart, or what data is shared, and if your outputs are automated, just tell it. The outputs are automated, and that's enough to actually satisfy that transparency requirement we were talking about a couple of minutes ago. You got to have to add anything?
I guess in the interest of time, we should skip and move forward because we still have 6 blocks to cover.
Okay, but I have good news. The boring part is over. Now we're moving to more fascinating IP issue. IP, it means intellectual property. And that's the fascinating part because it's actually a dispute who actually owns the AI-generated content and how not to get actually sued for what your model said. Um, just to be quick here, we're going to be very quick because in theory, it's nothing to say here, but we have a lot of very great examples of how it actually works. As I said, the lines are quite blurred because between the intellectual property, copyright, AI-generated content, um, because nowadays it's very easy using the AI instruments to create blog posts, to create design, create logo. But if you did it using a model, it doesn't necessarily mean you own it. And moreover, it doesn't necessarily mean that someone else doesn't own it. For example, you might have generated an image and the AI model you're using has generated it basing on very famous Disney images. So here the copyright issue is like obvious. So the key questions every startup should ask is who owns the input, who owns the output, and how can we safely use or commercialize it? Igor, you wanted to tell us something about the ownership of the input in AI models.
Yeah, that's very briefly, that's the main one of the main problems. What data you're using to train the models and what are the results you're getting, and like what you can do, what you cannot do, and so on. And we'll walk you briefly across major markets like the US, the EU, Korea, Japan, China, and so on. So outputs, so everything that is used to train the models. Who owns that? Most legal systems, they still require human authorship for copyright protection. And if you're using like purely AI generated results, they are like not protected. They're not copyrightable. Inputs. Sorry, messed it up. Inputs, something you use to train data. Output, something you get as a result. So for outputs, if you want to register that, if you want to commercialize it, you need to add some human touch. Something purely generated is not protected. Inputs, so something you use to train your systems. The rules are different in different jurisdictions. In the EU, they rely on text and data mining exceptions, which is normally used by researchers. And this is the basis for training the models. Japan has a broad data analysis exception. The United States, they are relying on fair use doctrine, among other things, to justify model training. So we'll skim some details and go to like what people struggle mostly in such questions. So like, what is the amount of human involvement into final production of whatever you're doing, like whatever content you're trying to produce? What is the sufficient amount of human authorship you need to add if you're using AI, if you have some assistance? It's normally decided on a case-by-case basis. The regulators, they issue guidelines, so you can rely on that. There is still like harmonizing of rules in Europe regarding opt-outs for content holders. The approach in Europe, if you as a content producer, content maker, you don't want your content used for AI training, you should opt out. You should use like specific automatic means in your files, in your website, and so on, to communicate automatically, like don't use my content for AI training. Um, and like quick takeaways from that. For something you want to claim your IP, document what you did and retain the evidence to show like this is how I produced this content, this is how I made the source code, this is how I designed this game, and so on. For inputs for something you use, build AI training governance register. Know what you're using to train your models. If you plan to register copyright, if you want to claim invention, map and memorialize human inventive steps. So going a little bit back to the examples, the Swedes practice like real case law from here. We have most of cases from the United States. One of them I like a lot is a case involving Thomson Reuters and Ross Intelligence. So Ross has been using snippets, like parts of Westlaw analysis. This is like a legal database which gives like quick summaries for lawyers about like developing case law rules and so on. So Ross, they used these head notes to train their legal AI search engine. And the court found this problematic and ruled in favor of Thomson Reuters. So this was one of the first cases when proprietary legal content was used for model training, and it's been found that this is a violation. Another example involves Anthropic, where a group of authors they sued Anthropic, the maker of Claude AI model, alleging that they used millions of copyrighted books. Some were purchased lawfully, others illegally pirated to train their models. And the authors claimed that it violated their copyrights and they sought damages. The court mostly that they issued a split ruling. They said that the books which were lawfully acquired, they are okay. They can be used for model trainings because the court found the process to be highly transformative and not harmful to the market. However, the court rejected fair use for pirated, unauthorized copies of the books and left that portion for trial. Um, so practical outcome here is like the sources you use. If this is like lawfully acquired content, this is one result. If this is pirated content, you might have some problems. Another case involves Facebook Meta, when a group of authors they allege that Meta's Llama language model was trained again on copyrighted books, including some from pirated sources. Last year, the court mostly dismissed the claims, and it was a procedural win for Meta. However, it's important to highlight this case that there is a huge evidentiary burden on creators of content to prove that training of third-party models, that there was a market impact, that they cannot license their content, so that there is like real harm to them. Another case involves Stability AI. There was a group of visual artists, and they sued Stability AI, Midjourney, Divine Art, Runway, and they alleged that their copyrighted works were used without their permission to train image generation models. They relied upon DMCA, which is normally used to fight with copyright infringements on the internet. It's an old law from late 1990s. The court partially dismissed the claims, but let them the direct copyright infringement allegations and allowed infringement theories to proceed further. And the judge finally ruled that the plaintiff's allegations, they were plausible, that copyrighted works might be included in the AI model in algorithmic or compressed form, and that defendants might have promoted the model in a way which encourages infringement. However, the court dismissed the copyright management information claims, so that means that the way the content is like distributed, the way the users are working with that later. So the outcome here, it's very difficult for content creators to prove knowledge and intent of AI model developer. Next case, it's about right to publicity and voice cloning. So voice actors Paul Lerman and Linnea Sage, they filed a lawsuit against Lavo, claiming that the company used AI to clone or mimic their voices without permission and then commercially licensed those voice replicas. What's interesting here is that they did not rely solely on copyright or trademark law, that they relied on right to publicity. This is the right to control your use of voice, likeness, identity. The court dismissed most of copyright and trademark claims. However, the court let the right to publicity claims to proceed further. It shows that when you cannot sue AI service providers under copyright theories, you can go to like other legal rights, and they succeeded in this case. So when startups are considering voice cloning or AI narration, you should be careful. You should get permission. You should design opt-in, opt-out flows and document consent and preferably licensing terms. That would be the best outcome. Next is my favorite example, and I discovered it while preparing for this presentation, and it involves George Carlin. So you might know this comedian. Podcasters, the podcast is called Dudesy. They released a 1 hour comedy special called George Carlin, I'm Glad I'm Dead. They claimed that an AI had listened to decades of George Carlin's routines and then mimicked his voice, style, and the topics he's been covering. This episode, it sparked a lot of backfire from George Carlin estate. They filed copyright infringement and violation of Carlin's rights of publicity lawsuit. And it ended up with settlement. So it did not proceed to the end. And the defendants agreed to permanently remove the special from all platforms, refrain from using Carlin's voice, images, likeness in the future. There is no information about financial or like other compensation. Another close case, you might heard of it, when OpenAI were deploying chatbots called Sky. They reached out to Scarlett Johansson and they asked her, "We'd like to use your voice." She said no. And then they used the voice, which was very, very similar to hers. She was shocked and angered because when she gave her friends and relatives to listen to the voice, they could not distinguish this voice from hers. I haven't found information whether this case is still pending and so on, because initially OpenAI said like we would stop using this voice, and Johansson also relied on her right to publicity. So this is another example where this is used in disputes with AI companies. And finally, what I'd like to cover, it's not about case law, it's about commercial practice. So one of the fundamental problems here with AI training using copyrighted works, images, voice, and so on is like, do you rely on fair use? And you say like everything which I can touch, everything I can get my hands on, I can use for model training. Or you go and you license the content to train your models. So these are like two opposing sides, and you cannot sit on both chairs at the same time and say like, when it's not fair use, I rely on licensing, and when it's not licensing, I claim fair use. It doesn't work like that. The problem comes that from the fact that companies like OpenAI and others, they license content to train their models. They pay between $1 to $5 million annually to license archives for training their models. Recently, Disney and Universal, they sued Midjourney and they allege that they've been using AI on their copyrighted images, trademark images like Darth Vader, Elsa, and so on. And there's a huge move from like big companies with established brands to push all AI generated content, which like parasites and this is one of the major developments to follow. And a final remark here, my favorite. Normally, when you create some content and it's copyrighted by default, we rely on 150 years old law, like Berne Convention. By the fact of creation content, you have the rights. You don't need to do anything. However, in certain markets, you might want to register copyrights. For example, the United States or China. Normally, the companies do that in the United States because it alleges that your company is the author, your company is holding the rights. And second, and most important, when you have copyright registration in the United States, when you go to court and you seek damages from the company which copied your content or used your content illegally, you can recover not only the damages, but also the expenses on lawyers. And usually this is bigger amounts than the reward you would get. So you can get $1 million of damages and you spend $5 million on legal fees. So when you have the option to recover legal fees, that is huge. However, the problem with like current processes, the companies normally don't think that they should document where they use AI. Is this character like fully created by human? What is the AI generated proportion? They have no clue. They don't care because they just want to move fast. They want to optimize their processes and so on. And let's assume that your company, without this process, you went to Library of Congress, you got your copyright certificate, and then you're trying to sue my clients for copyright infringement. So first thing I do, I would go and seek all public information about how your company is using AI, improving efficiency of your business and everything. Secondly, if I figure out that you haven't properly disclosed where you use AI in creating your content, I would challenge your copyright certification. And I would do that in order to kill this registration. So you would lose your right to recover legal fees. And that will like invalidate the whole point of like registering copyright in the first place. So the practical outcome, you need to understand how you're using AI when you create content, so you can properly register it and use that in code later. So gradually we move to practical tips for your business. So this is one of them. So document your use of AI to distinguish AI generated materials from human made materials. And Anna, do you want to add something on practical tips here?
Yeah, sure, absolutely. Thank you, Igor, for the examples. That was interesting, especially about the legal expenses. Usually we think that if I won the court, so I get the expenses, but not when the AI comes in play. That's interesting. So, how not to find yourself in such a situation? First of all, it's wise to choose and to use AI widely and extensively, but only for drafts, not for final outputs. Please, please, please add something human to the output to be able to claim the authorship, to apply the copyright. So that's really important. Then please pay attention to vendors you work with. Choose them wisely. Read their IP terms. It's really important to understand who owns the output. Does the provider use my data for training? And unless it's absolutely necessary. Please don't use free or experimental tools unless you understand their licenses. Many of them just forbid commercial use. And you may own the output, but you won't be legally permitted from to use it, to commercialize it, to use it in your product. And what's the point using them if you can't use it again? Verify your outputs. Just run AI-generated names, text, images for a quick copyrighted trademark search before publishing and selling, just to be on the safe side and to be sure that Disney won't knock on your door late at night claiming all the damages and all the monies you've ever earned. And if your users using your product also create their content, it's a good idea to define the ownership of those products in your terms of service. Just clearly state that your users own their product, or you own whatever your users have generated. Say if you grant or receive a license to use it. Add a disclaimer that you're not liable for infringing your illegal output, something like that. The general rule here is that when it's not written, it's a gray area. And when it's gray area, usually it gets expensive. So it's a good idea just to be on the safe side and to put everything in writing and on the paper. And then just let's move on to bias and fairness in using AI. I think here will be quite short. I think the main idea in this blog is that AI doesn't invent bias. AI learns it. The models, they are trained on real-world data. And as a result, it absorbs real-world inadequacy that exists in that data. Regarding race, gender, geography, income, language, culture, you name it. Regulators actually are starting to treat bias and unfairness in the automated systems as sometimes data protection and sometimes as discrimination. So what do we mean by discrimination risk? For example, discrimination usually happens when your AI model or when our AI system treats certain people or groups of people unfairly because of their gender, race, income, etc. For example, it may happen in hiring processes when your automated decision-making system just thinks that male candidates are more prospective than women. Why it is a privacy problem and not just ethics problem? Again, a little boring facts from the privacy laws. GDPR says that the processing and what happens during the AI working on all the data, it's processing. And GDPR says that it has to be lawful, fair, and transparent. Then GDPR says, when your system uses data and it makes some decisions solely automatically, you have to tell your users that is happening, and then you have to provide them with an opportunity to get a human involved. So when AI makes or influences decisions, hiring, calculating credit risk, pricing, targeting, it doesn't matter. Fairness and absence of bias is not an option. Actually, it's a compliance requirement. Speaking of the automated decision making, in privacy language, we call it profiling. And when you hear profiling, when you understand that the system is making decisions that influence people or have some legal consequences, it means high risk. And if it is high risk, you have to have special documentation basing the separations. It calls data protection impact assessment. It's quite a big deal, I would say. Then you have to explain its logic and consequences to your users. And once again, you have to provide the possibility to opt out. So when someone comes to you saying, I don't want your AI model to make a decision about me. I want a real life, a human recruiter to look at my CV. You have to be able to provide this opportunity. That's what GDPR says, and that's why all buyers they actually form real legal risks. I guess Yegor will have some examples to illustrate this.
Yeah. So again, as Anna said, most of them are from recruitment process. So one example is from resume screening. Researchers tested how three large language models ranked resumes with names linked to gender and race, and they found strong bias. So models disproportionately favored white associated names over black ones and female names too. And even it happened even when qualifications were similar, were constant. Another example involves Workday AI hiring tool. So there is a lawsuit, there is a dispute around that this software disproportionately rejected applicants over age of 40, along with claims of racial and disability discrimination. And the case is still going on. Another example involves OpenAI's Sora video generator. So they recently renewed it. And Wired's magazine investigation, they found that the output, the videos generated by Sora, they reinforce gender, racial stereotypes because they depicted professionals as mostly male, caregivers or receptionists as mostly female, and defaulting to able-bodied people. And like the worst consequences you have is like the reports from Washington Post when they uncovered multiple cases where police departments made arrests based solely on facial recognition matches, and they often involved low quality footage. And it again disproportionately affected like Black individuals. And these misidentifications illustrate how algorithmic bias in AI systems they can lead to uh, severe real life harm. Back to you, Anna.
Oh, already. Well, I think we'll be short here and just give you some tips on how to avoid bias, stay ethical, and still use AI in your product. Well, I think the most obvious, most important thing is try to keep a human in the loop, especially for sensitive cases. Don't let AI make final decisions in hiring, pricing, healthcare, etc. Always make visible that you have a human reviewer. That actually helps a lot. It's good to diversify your training data to actually avoid this biased outcome the AI system may gain from training on very how to say underrepresented data sets. For example, not just English language, not just male, not just Western data. Make your data sets as vast as possible. Then please don't overpromise natural AI. the synonyms are objective, unbiased, 100% fair, etc. It's better to say that you actively monitor and improve fairness, because you never know, like, whether it's like really 100% fair. Yeah, and actually test the model for fairness. The better you're prepared, the better actually. Um, and let's move on to our next block, transparency and accountability. And here we wanted to talk a little bit about the black box problem. So what does that mean? What is the black box problem? Actually, it means that AI works great, but few can explain how exactly it happens. Actually, no one cares until regulator asks you, how did your system make this decision? Or a user asks you, why actually I was denied, or why I was excluded from some role, for example. Or an investor asks, can you prove that this isn't unlawful? And here we come to the understanding that AI works invisibly, its logic is nonlinear, and actually that is a problem because, again, from legal point of view, under GDPR, data must be processed transparently. It means users of your product, namely, they have a right to know how their data is used and for what purpose. You have to give explanation of the logic involved in the decision making. So this is actually the black box problem. If you do not understand how it works, you can't explain how the model made a decision, it means you can't defend it. It means you can't comply with the basic GDPR and actually CCPA as well requirements. Also, that is an accountability issue. What I mean, it's natural for us, like normal humans, to say, it's not me, the model did it. But from the legal view and from the regulatory view, it's you who did it. It means if something goes wrong, it's not the API's fault, it's your fault. So you have to understand and document what's going on in order to control it. You have to document your decision. And at the moment, it may seem burdensome. It may seem like more legal documents, we don't have to do it, we don't have time to do this. But when something goes wrong, not even when, something will go wrong. But if you document it, if you will pay attention to how the model works, you will be on safe side, especially it will protect you legally. I guess Igor will share some examples
Yeah.
of that problem.
We don't have a lot of practice in this area yet. So as Anna said, one of the challenges is responsibility in AI systems, especially when they made of multiple autonomous agents. And the problem is it's very difficult to say like what went wrong in this chain of decision making. And this is a big problem for the companies developing such tools because they would likely be held accountable. However, we have a good example from the US bank called Wells Fargo. You might know them. So Wells Fargo described its efforts to build explainability in its AI models. They have a virtual assistant called Fargo. They capture metadata with each decision to show why AI made a particular choice. So their internal testing includes explainability checks and post hoc interpretations to validate model behavior and catch weird outputs before they are released to their customers. So this demonstrates that AI does not have to stay as a black box and that transparency can be designed into the system from the start. And that's, in essence, we're moving to practical conclusions. We said about that you have to understand how your systems work, why you get the outcome in order to explain to your customers, to the judge if you end up in court. But this example of Wells Fargo, it also shows that if you're transparent, that builds trust with your customers when you explain to them how decisions about them are made, especially using AI systems. And that means bigger trust from your customers and from your partners. As we're running out of time, I suggest we cover really briefly regulatory uncertainty and the regulation we have at the moment. Skip the part about vendors, and I would try to be very, very brief about litigation.
Yeah, great. I think I will be very short on regulatory uncertainty. I just wanted to share that, guys, we lawyers, so privacy professionals, we are as afraid as you are, because the legal landscape nowadays evolving rapidly, and every day something happens. A new act, a new rule, a new guideline, new draft. So like my LinkedIn feed is just filled with new something which was admitted or adopted in different countries. The nature of AI-powered systems and products is that, unfortunately, they fall under several regimes at once. Under the EU AI Act, under the US FTC enforcement, under the Canadian bills, or privacy regulations in Singapore, Japan, etc., etc., etc. And even a small startup can fall under all of them. So it's really hard to keep everything in the loop, to answer all the previously simple questions. For example, who is the data controller? What is personal data in this landscape? How to actually get users that rights that they claim, for example, right to access or right to correct or right to delete their data. How to prepare for AI Act, how to tell that my system is a high risk or it's not a high risk. And I think here the golden rule is that while regulators don't agree, the best option is to act as if the strictest rule apply. For example, if you like from the privacy perspective, the GDPR is. So if you comply with GDPR, it's 95% possibility that you are okay with like anywhere in the world. At the moment, no one is absolutely sure of how to actually regulate the field. But it's evolving, it's developing, and we are keeping an eye on it. Igor, was it short enough?
Yeah, yeah. Moving on to our final topic. So we are running out of time, so we won't be covering vendors and how you're choosing your AI systems because the last part, in my opinion, is like way more interesting because it involves litigation and again real case law. So we have recent news because we're in Portugal when the judge is currently under formal disciplinary investigation after the lawyers of the opposing side, they found that he's been drafting the ruling using AI, and they found non-existent case law, weird references, suspicious language, and so on. So this shows that AI is affecting legal professionals too, and even when you end up in court, there still might be a problem that the judge would be using AI tools to make a ruling in your case. And final story that I want to cover today is about litigation and use of AI, mostly about voice transcription tools. So for example, if that would not have been our presentation, but it's been a work chat or like a work conference, and we might be using AI transcription to keep record of everything we're discussing at the moment. So that sounds great because we can not care about making notes as we go. We can get back to our notes, which would be AI generated after we finish the call, and it's a cool practice. We don't miss anything. But there is a problem. There should be some real value behind that. So if we're keeping transcriptions of the calls, how regularly do we use them? Is it a value, or is it something that we never get back to? Is this a useless paper trail? Why I'm talking about this? I had unfortunate experience of being involved in US patent litigation and getting very familiar how discovery works. It's a very annoying process, which normally involves recovering all the documents the company has relevant to the case. And this involves emails, in some cases, Slack messages, like whatever electronic information from your project management software. It can be Jira, it can be Asana, like whatever you use. We go there and we'll recover everything related to the case. So it's a very burdensome process, and using AI transcription tools adds an extra layer of problem. So if in this hypothetical example, we're using AI transcription tools, when we talk on the calls, normally we do not stand to the same standard as when we're writing because it's slower when we write. So we talk a lot and we might say some things. We don't want to be on paper. We don't want to be on record. And with this AI transcription tools and the content they generate, uh, me acting as a lawyer of the opposing side, I would be counting so much on everything that's been generated using these tools because I can uncover so many useful information people normally do not expect to share in court. So this is why there's been a practice saying like this is not on the record. So when you're using AI transcription tools, weighing like how much value you get from that, where it's stored, practical tool is like sets retention periods. If you haven't looked into transcription file for more than 1 month or 3 months, like whatever works for you, delete it. And that will save you a lot of money and time and nerves.
Yeah.
So that's final take from me because we're running out of time. Um, that's it.
Yeah.